Have you ever been there? You walk away from a negotiation, you're feeling fantastic about all the promises that were made, but then, when you look at the final contract, poof, they've just vanished. It's an incredibly common problem. So today, we're going to dig into what actually counts when you make a deal, and what's just, well, talk. Okay, let's paint a picture. You're buying a used car. The seller looks you in the eye and gives you that super reassuring line, "The engine is perfect." You feel good about it, you shake hands, sign the papers, and you drive off. But then, a week later, that perfect engine sputters and dies. So, was that promise legally binding, or was it just hot air? You know, the law gets it. Negotiations are messy. They're full of chatter, back and forth, people saying things to build rapport or just to get the deal over the finish line. That's why the legal system has this sort of filter, a way to sort through all that talk and figure out what's just sales puff versus what's a real, concrete, enforceable promise. And that legal filter works by splitting all those pre-contract statements into two very distinct categories: terms and representations. And trust me, getting the difference between these two is the absolute key to understanding your rights in any deal. So first up, we've got a term. The best way to think about a term is like a foundational building block of the entire agreement. It's a promise that's so important it gets baked right into the contract structure. If a term is broken, it's not just a minor issue. The contract itself has been broken. And then, on the other hand, you have a representation. Now, this is a statement that's made to kind of coax you, to persuade you into signing on the dotted line. It's important, for sure, but it isn't meant to be one of those core building blocks. It sort of floats outside the main structure of the deal. So let's just boil this down, right? Terms are inside the contract. They are the legally binding promises. Representations are outside the contract. They're the statements of persuasion that get you to sign. And believe me, this one simple difference changes everything about what happens if that statement turns out to be false. Okay, so you might be wondering, how in the world does a court figure this out? I mean, they can't read the seller's mind, right? Well, they don't have to. Instead, they use something called the intention test. It's a framework for figuring out what the parties objectively intended. And really, it all comes down to this one question of contractual intention. Was this statement actually meant to be a binding promise, a core piece of the deal? That is the ultimate question that a court is trying to answer. But here's the crucial part. This is not about mind reading. It is an objective test. The court isn't trying to figure out what someone was secretly thinking. They just ask, based on all the words, all the actions, everything that happened, what would a normal, reasonable person conclude? Was this meant to be a serious, binding promise? And to figure that out, courts basically look for clues. For instance, how important was that statement to the person who heard it? Did they make it clear it was a deal breaker? What about the timing? Was it said right before the contract was signed? Did the person saying it have special knowledge, like a mechanic talking about an engine? And maybe the biggest clue of all, did they bother to put it in the final written contract? Now, I want to be clear, this isn't just some boring academic exercise. Whether a statement is a term or a representation has huge, real-world consequences if that statement turns out to be a dud. Think of it like a fork in the road. The legal path you can take and the solutions available to you completely diverge based on this one classification. If you get it wrong, you could be heading down the completely wrong legal path. So here's how the fallout looks. If a term is broken, it's a straightforward breach of contract. You can sue for damages based on that specific broken promise. But if a representation turns out to be false, that's a potential misrepresentation. Now, this might open up different options, like trying to cancel the whole contract, but it is a totally separate legal action. All right, let's pull all this together. The goal here is actually pretty simple. It's about being fully aware of what you are actually agreeing to. It's all about getting that crystal clarity before you put your name on anything. So here it is, your simple 3-step takeaway. First, when you're in a negotiation, actively listen to tell the difference between persuasive talk and a concrete promise. Second, ask yourself or even ask them directly, is this intended to be a binding part of our deal? And third, the golden rule. If a promise is a make or break issue for you, you have to insist that it gets put into the final written contract. No excuses. And the logic behind this is really solid. A court's perspective is generally, look, if this was so important, if it was truly meant to be a core binding promise, the parties would have written it down. The fact that a promise is missing from the final document, well, that speaks volumes. So the next time you're hammering out a deal, whether it's for a car, a job, or anything else, just pause for a second and think about the promises being made. Which ones are you okay leaving to chance, and which ones are so critical that you need to lock them down in that contract as a formal term? Because ultimately, that choice is yours. Thanks for tuning in.